Welcome back. In this discussion, we focus on Indian patent application process. So if you are a resident of India, an inventor and desirous of protecting your invention by getting a patent, continue watching for vital information. So where to file a patent application? What is the duration of patent protection? What are the rights of a patentee? What is the patent process? Let us know the answers to all these questions very quickly. India, unlike many other countries, has patent office functioning from 4 different locations: Mumbai, Delhi, Kolkata, Chennai. So where to file the patent application? The application needs to be filed with the office of appropriate jurisdiction, meaning the office that covers the state or union territory of the applicant's address for service. And what is the duration of patent protection? The duration is for 20 years. But please note that once the patent is granted, the calculation of 20 years begins from the date of the application and not from the date of grant. Now, let us understand what are the rights of a patentee. When the patent granted is for product, the patentee has an exclusive right to manufacture, sell, use the patented product as well as import the patented product in India. Whereas, where the patent granted is for process, the patentee has an exclusive right to manufacture the product with the patented process, to sell it, to import it, when the product is exclusively made by the patented process. But what if the invention that you have been working so hard on or planning to work is already in the public domain? For an inventor, it is of high importance that an in-depth search of prior existing patent in the field of invention be done. It gives a picture of where your competitors are placed and also directs the area of invention that can be worked on. So the patentability search, or also known as prior art or novelty search, is advisable at various stages of research and development of an invention, depending on the field of the invention. But in case you have not done the research, required necessary search, then at least prior to filing of a patent application or drafting a patent application, it is necessary that in-depth search be done to rule out that any prior patent application similar to your invention is already in the public domain. Next question is, can all claims of invention be protected under the Indian Patent Act of 1970? To get protection under the Indian patent law, your invention needs to qualify the test laid down primarily under Section 2, subsection 1J, Section 3 and Section 4 of the patent law. What does Section 2, subsection 1J say? It defines what an invention is. Accordingly, an invention can be a new product or new process, which must involve an inventive step and must be capable of industrial application. So what does inventive step and industrial application mean? Inventive step means that the new product or process should be technically advanced compared to the prior existing knowledge, or it should have economic significance, or both. And in addition, it should not be obvious to a person who is skilled in the field of the invention. Now, the other term, industrial application, simply means that your invention should be capable of being industrially manufactured. So, Section 2J lays what qualifies as invention, whereas Section 3 and Section 4 detail what cannot be patented. As per section 4, if the invention belongs to atomic energy, that is the provision under section 20 subsection 1 of Atomic Energy Act, then it cannot be patented. Whereas section 3 provides a list of categories, about 15 categories of what are not considered as inventions and cannot be patented. I shall try and make a detailed video on section 3 and all the categories under it. But for now, let's move ahead on what's the patent registration process in India. The most important document that accompanies the application is termed specification. This document details the invention. It discloses the best method of performing the invention. Being a techno-legal document, it should be drafted by a person with desired skill and who is also aware of the patent law details. It can be an inventor or a patent professional. Indian Patent Act provides provisions for filing patent application at two different stages. The first one is application filed with provisional specification. Now let's understand this. Suppose if the invention is at final stage of development but not yet complete, and the applicant desires to safeguard his rights. So at this stage he can file a patent application along with the specification of invention, which is called as provisional specification. This provisional specification, although it discusses the subject matter of the invention, but the entire detail is not required. The entire detail is to be only filed when the invention takes the final shape. So you have filed patent provisional specification. Now the next question is, since this is not an application which is complete, it does not provide with all and final details of the invention. So is there a time limit to file the final version of your patent application? Please note that there is a fixed time limit for filing the final version of your application, which is within 12 months of filing application with provisional specification. You need to file complete details of your invention in the form of what is called as complete specification. This 12-month time to file complete specification is absolutely mandatory. Within 12 months of filing application with provisional specification, complete detail of the invention in the form of complete specification is mandatory to file. And in case it is not done so, the application will be deemed abandoned, considered invalid. Now let's move to the next step. Once an application is filed, the next stage is the publication of the application. Applicant doesn't need to do anything for publication. This publication is in official patent journal by the patent office, and it is automatically published after the lapse of 18 months from the date of the application and is open for the general public to view. But in case where the applicant desires that his application should be published earlier, he doesn't wish to wait for the 18-month period, then he can make an application request along with the required fees, and once this request is received by the patent office within 1 month as per the law, the application along with the documents is required to be published in the patent journal. Once the application is published, the next is post-publication stage, which is that the patent office ascertains whether the claims detailed in the complete specification actually qualify as invention as per the criteria discussed earlier, laid down under the Indian Patent Act of 1970. This is done at the stage of examination of patent application, which is after the publication stage. But please note, unlike publication, which is automatic, For examination of patent application, applicant has to mandatorily file a request for examination, and this should be done within the 48 months from the date of the application. Filing this request is mandatory. Now, after the filing of request for examination of patent application, it is followed by the examination process, whereby the examiner at the patent office conducts a search in the patent database to find out whether any prior publication that already anticipates applicant's claim and whether the claim in the patent application qualify as invention. This is done under section 2 subsection 1(j) as discussed earlier, which lays down the criteria of novelty, inventive step and industrial applicability, and under section 10 subsection 5 whether there is a unity of invention, also whether the claims are affected by the provisions of section 3 of the Patent Act, which, as already stated, lists what are not considered as inventions. Now, on the completion of the examination process, if there is objections with regard to the patentability of invention, the Indian Patent Office forwards a statement of objection to the applicant. On receipt, the applicant has to file his reply within the period of 6 months or within further extended period of 3 months. The applicant can also request for a hearing to explain his case properly. In cases where hearing takes place, in addition to presenting the case in hearing, the applicant can also submit written submissions and relevant documents within the period of 15 days from the hearing. Now, on addressing the objections raised by the Patent Office and carrying on any necessary amendments if required, the Indian Patent Office grants the patent by assigning a specific serial number. So this is in brief the patent registration process followed in India. I hope the information in this video is of help. Till we meet again, take care and happy inventing.